The nation continues to reel from the horrific deaths of three precious sisters whose bodies were found days after a planned visitation with their father. Joining us to unpack how the system may have failed these girls is Alesia Flores, attorney at law. Thank you so much for being here with us.
Thank you for having me.
So as of the recording of this segment, the father has still not been located. It sounds like he is a bit of a survivalist. He knows how to survive in the wilderness for extended periods of time. Something that struck me, though, is that it is documented that he had some emotional instability, yet was still granted visitation with his daughters, all of whom were under the age of 10. So where, in what research you've seen or done, did the system potentially fail these girls?
You know, I am not sure. You know, I think one has to look at the totality of the circumstances when determining whether or not supervised visitation is appropriate or if no visitation is appropriate. And in the state of South Carolina, the court is going to look at what is in the best interest of the child. And they're going to examine a variety of factors in making that determination.
And something that you and I had spoken about just before we got started here is the fact that it didn't appear that the mother had raised any flags when they were determining visitation with the father at the time of their divorce.
Right.
So he was granted, I believe, a few hours one day a week and about 8 hours every other weekend. But again, these were not supervised visits. So how much of, lack of a better term, onus is on the other parent to maybe make sure that supervised visitation is part of that agreement?
Yeah, you know, unfortunately, this is a tragic situation, and hindsight is 20/20 in situations such as this. What could have happened? The parent could have petitioned the court for supervised visitation or no visitation at all if she had concerns about the father's mental health stability.
Yeah, and when a judge is making those determinations based off of both parties' reasoning and desire out of the agreement, how do they weigh that? Because if, let's say I'm a mother and I'm saying I absolutely don't trust my soon-to-be ex-spouse to have unsupervised visitation, yet my soon-to-be ex-spouse is saying, no, everything's fine. I have every right to be with my children alone. So how do they weigh that?
Okay, yeah. So as I stated, the court is going to look at what is in the best interest of the child. So they're going to examine various factors, an array of factors, in order to make that determination. One could be the housing stability of one parent. If one parent has an unstable housing situation, then the court may say this could be detrimental to the child. If a parent is struggling with mental illness, then the court is going to ask, how does this mental illness, how could it be detrimental to the welfare and safety of the child? And so those hard questions have to be asked in order to ensure the safety and well-being of the child who may be visiting with a non-custodial parent.
So there's a lot of factors that play into this, and it sounds like at the time he was homeless. So these agreements are not written in stone. They can be changed, and
that is correct.
They can be adjusted as time goes on. So knowing what his living situation was like at that time, a mother in any situation like this has every right to,
absolutely,
even in an emergency hearing with the courts, to have something changed?
Yes, yes. So in this state, a child support or a child custody order, a child visitation order is always modifiable if one party can show there has been a substantial change in circumstances. So if a parent has housing and they become homeless, then a parent can bring that back to court and say, I'm concerned, I'm going to petition to modify this agreement or this order based on this change in circumstances. So if concerns regarding the mental health of a particular parent comes up as well, then yes, a parent can certainly petition the court to modify the order.
Okay. Now, concerns like mental illness and things like that, not necessarily a mark against that person. So if they are undergoing therapy or other treatment, that doesn't necessarily preclude them from having unsupervised visitation.
Correct.
Right.
Mm-hmm. That is correct. I mean, every parent has a right to visit with their child, and they can petition the court for visitation or even custody. And so if they have a mental illness, if they're struggling with mental illness challenges and they're being treated for it and they're remaining on medication, following a doctor's orders, then they're certainly not precluded from visiting with their child. Right. But the court, yet again, will still ask what is in the best interest of the child, and the family court's top priority is to protect the safety and well-being of the child.
Okay, all right. Well, we do need to take a break here, but when we come back, I want to talk about the Amber Alert situation, because it sounds like that system might be broken as well. So we're going to do that when we come back in 2 minutes. Don't go anywhere. Welcome back. We've been chatting with Alesia Flores, attorney at law, about the Decker sisters, these three beautiful sisters whose lives were cut short because of a planned visitation with their father that he is suspected in their deaths. And it sounds like the mother did what she should have done when the sisters did not arrive back home as planned. She called the police, yet an Amber Alert was never issued. Why is that? And it sounds like the system is either broken or could use a renewed purpose.
In the state of South Carolina, in order for an Amber Alert to be issued, law enforcement must believe that a child has been abducted, the child is under the age of 17, and there is the belief that the child is in immediate danger of serious bodily harm or death. Law enforcement has ruled out all other possibilities regarding the child's disappearance. There must also be enough information to disseminate to the public regarding the child. And finally, in South Carolina, the child's name must be entered into the National Criminal Information System Center.
Okay, I'm just curious though, if the sisters were even 30 minutes late, an hour late at arriving home, that should be reason to assume them missing.
Yes, I mean, we all would prefer that law enforcement err on the side of issuing the Amber Alert as opposed to not issuing the Amber Alert.
And it sounds like the Wenatchee State Police, they issued an endangered missing persons alert, which is very different from an Amber Alert. An Amber Alert is something that you get those notifications on your phone.
That's
that
right.
It's blasted out there for everybody to know. Potentially could have saved these children's lives.
Yes.
So here in South Carolina, does it work the same in every state? Is there an extra, I guess, level of protection for children?
Yeah. Well, in our state, those are the criteria that must be followed. And I think they are reasonable criteria to apply in circumstances such as this. In this particular instance, yeah, I mean, I wish law enforcement had issued the Amber Alert. There sounds like there was enough of a concern from the mother.
Absolutely.
She called law enforcement. She was concerned about the fact that the children weren't returned. She was most likely frantic.
Yes.
So I wish that the Amber Alert had been issued in this particular situation.
In the event that they refuse to issue an Amber Alert despite a person's pleas, what recourse does that person have to try to move things along? What can they do so that they're not disempowered?
Well, you know, the parent contacted law enforcement. So law enforcement can intervene. They can start the search. She could elicit people from the community to participate in a search. They could blast it on Facebook, share it. She can also petition the family court for an emergency hearing. Although in this particular situation, in all likelihood, I'm not sure if the family court could have intervened fast enough in order to stop the situation.
Sounds like a 24-hour process.
Yes.
Yeah.
Probably at least 24 hours before there can be an emergency hearing.
Oh, goodness. Well, this is just such a horrible story, and hopefully the father, whoever did this, will be brought to justice. It sounds like all roads are leading to him.
Yes, yes.
But I really appreciate you coming on and sharing this critical information. And for anybody who wants more information on you and what you do, where can they find you?
Okay, well, you could visit my website, alesiaflores.com.
Great.
ALESIAFLORES.com.
Wonderful. Thank you so much, Alesia.
Thank you.
Appreciate your time.
Thank you.
We'll be back after this.